anyone write down questions for Dr. Menzel on a card? We can just pass the mic around for any questions that we have tonight. But we'll go ahead and get started, as we always do with our pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And then our land acknowledgement. As we gather for this meeting, let us take a moment to reflect on the meaning of place, and in doing so, recognize the various traditional lands on which we do our business today. We wish to acknowledge this land on which this SPC meeting is taking place. For thousands of years, it has been the traditional land of the Hohokam, the Akimel O'odham, and most recently, the Salt River Pima Indian community. Today, this meeting place is still the home of many indigenous people from across Maricopa, and we are grateful to have the opportunity to live and work on this land. Okay, so for our agenda tonight, we have 15 minutes with Dr. Menzel for any questions you have. And then we have Lori Bird joining us. She's the SUSD General Counsel, and thank you to everyone who submitted questions in advance. I think she put together a presentation that addresses most of those questions that were submitted, and then you'll also have an opportunity to ask her additional questions. And we have a few executive board updates, a couple committee updates, and then any announcements from SBC representatives if you have them. So with that, we have Dr. Menzel. Did we get any cards?
Just name tags.
Okay,
No cards.
So any questions? You have to speak into the microphone, though, so anyone who watches the recording can hear. Anyone brave?
You don't have to have questions. I have one comment, though. So as you all know, the legislature is dealing with the aggregate expenditure limit, and thank you for sending out the email that shared half of the story,
too,
which
so
is
don't
really
worry.
good.
We'll repeat it.
But we're not there yet. So we still have to have the Senate vote. They did not take it up today. We hope tomorrow. But that is the last piece. I fully expect the governor to sign it. So it's a glass half full today, but we need to get it across the finish line. And other than that, I appreciate the fact that you're here, that you continue to support the good work that's happening with our kids across our 29 buildings and our online school. And I'm always happy to answer questions, whether it's here or in another format, but I'm also happy to give back the mic and let you move on with your agenda.
Nothing? Wow, okay. Okay, thank you, Dr. Menzel. So with that, we have Lori Bird.
Good evening, everyone. I do like to wander as I talk, so if I start to make you seasick, raise your hand and I'll try to stand in one place. The very first question I got was, who am I and what do I do? So my title is General Counsel. That's up there on the slide. What I do is lawyer work for the district, pretty much everything short of full-out litigation. We have what's called trust coverage for that, and that gets sent out to attorneys who go into court on a regular basis. I answer questions from the school sites, for example. I interpret custody orders. That's one thing that I do. I review contracts, all the contracts for the district. I help write the district policies and make sure that we're in legal compliance. I help with any HR matters that may arise. I speak with our Director of Communications from time to time about matters that may arise. So any legal matter that comes up in the day-to-day running of a school district usually comes through my office. My staff is my paralegal currently. The risk manager for the district, who is William Berry. The paralegal is Louise Caseda. And Monica is workers' comp and student injury. You might hear from her if a student gets injured on the playground. She'll be the one following up with you and making sure that you have the information you need. So I think that checks off the first question is, what is a general counsel and what do they do? A little bit of everything is the short answer. If you want my background, I've been in education as an attorney for I don't know, 18 years or so. I've done a little medical malpractice, defended doctors in hospitals and nurses back in Massachusetts. I've done some criminal appeal work, including federal district court work, staff attorney work on capital habeas, death penalty matters. But the bulk of my career has been as an education attorney, and also some focus on special education and disability rights as well. So the next question I got, and I'm not going to take these in any particular order because we kind of have like a grab bag of questions. And so some of them I kind of were able to relate and some not. The first question I'm kind of going to get to, because it's almost on an island to itself, is what are public records requests? So you can always get your child's educational record, both the special ed record and the general ed record, including attendance and discipline. All you have to do is request that. That doesn't need to go through public records. I'm going to read you the definition of public records and then tell you that it doesn't really give us a whole lot of guidance, but this is what the law says a public record is. It's any record made or received by a school district, the law actually says agency or governmental agency, in connection with transaction of public business and preserved or appropriate for preservation by the district as evidence of the organization, functions, policies, decisions, procedures, operations, or other activity of the district. So if there's something outside of the educational record that you think, a contract, for example, I don't know, sometimes contractors want to see contracts, they want to see bids. You can make a public records request for that. That comes through my office. We have the ability to pull those records. We make sure that there's nothing confidential that a statute allows us to withhold, and then we give you a copy of that record. The time frame for that is promptly. And I will tell you, we really work really hard to be prompt. I can also tell you, because I will tell you in some districts you can wait up to a year for public records requests. We very rarely exceed, I would say, 2 weeks or so, and sometimes quicker. It all depends on how big your request is. What comes up a lot that I think frustrates people is emails are something that you would get through a public record, because emails don't become part of your child's educational record unless there's a specific reason for that to happen. When we pull emails, we might pull thousands and thousands of emails. Either the public records person or myself have to read through every single one of those emails to make sure that we're not releasing private or confidential information. That can take a while. Currently, we are not charging people for digital copies of records. So we'll go through, you get your request, you'll get an acknowledgement, we'll tell you we're working on it, we'll give you a time frame, and then we'll pull whatever that record is that you want. What you do need to know, though, is not everything's a public record. So sometimes you may think something exists, and it simply doesn't, or it doesn't exist in a form that's a public record. For example, a draft of something isn't a public record because it's not really the district's kind of evidence of their organization, function, and things like that. So I know that frustrates people, and if you have questions about, can I request this or not request this, is this something the district would have, you're welcome to call either myself or, when I hire my new public records person, it used to be William Barry, and he's now my risk manager, we'll let you know. We're not trying to hide anything in terms of public records. There's just sometimes a misperception that the district would have something that we don't have. And so that's kind of the overview of public records. I don't have no way of knowing who asked that question, but is there a specific question about accessing? And it's an online submission system, by the way, so it's real easy to do. You go online, you can go to the district website, you can find the link for public records, you can fill out your request, and it comes right in seamlessly.
Can you tell us roughly how many you receive and how much staff time is used for that?
So we're a very busy district when I compare to my colleagues. I do keep data. I didn't bring my data with me. I would say that we do allocate a staff person to do that. It was a full-time staff person before, and so it was a 40-hour-a-week job processing public records. Currently, the paralegal is doing it, and I would say it's taking up probably half of her time to process the public records. In any given month, we could get up to as many as 30. Summers are slower, generally. It all depends on what's going on in the district and what information people are trying to get. But we have enough work to have to employ a person to actually process our public records requests so that we can get them out to people in a timely manner.
Is that something that's just these past few years, or has that just been traditionally the district has had to do that?
I would hazard a guess. Remember, I've only been here since July. But from what I've been told, since about 2016, and even before, we've had a very involved community and a very savvy community that tends to make more records requests than the typical, some of our other surrounding districts. I don't have quantifiable data. I just hear other people talk and know that I know we're the only people fortunate enough to need a full-time person for that.
Are you okay with taking questions after
Yeah,
each kind
after
of thing?
this section,
Okay.
that way, so if it's about public records, go ahead and ask. If it's about
But
something
you
else,
have
I'll
to talk into
probably
the
get to
microphone.
it.
All right, you have to talk into the microphone, so I'll walk around with it.
You may use your teacher
Thanks.
voice.
Just really quickly, so to sort of piggyback on that, what would be considered an abuse of a records request? Like something that would be frivolous or something, so that the numbers wouldn't be as high as they are?
So one of the things we get a lot of is parents in custody cases trying to access the emails of the other parent to the teacher. We will always comply with the court order. So let me say that. If parents are working with an attorney and we get a subpoena, we comply with the subpoena and the judge figures out what's appropriate. It's not a public record what one parent emailed another parent about the child. If it's just about the child and it's something both parents should know, then usually the teacher's emailing both parents. But as a general rule, I don't have to give out information that violates the privacy rights of other people. We get a lot of those in custody cases. Lately, I'm going to be candid with you, we have gotten a lot of requests for one community member seeking the emails of another community member because of some political issue that happens to be going on within the district. Those take an inordinate amount of time, and most of the time, they end up being at least partially protected, and they don't concern our students or the running of our district. And so, to be quite candid, it's a little frustrating to have to spend time going through what sometimes thousands, and I'm not kidding, I can pull thousands of emails and having to go through those emails because the law presumes, rightly, that the public has a right to transparency. But that, to me, is, if you want my candid opinion, it is abuse of the process when you're using the public records request process as your personal private investigator firm.
Sure. Yeah. If you're going to be candid, who's the person requesting and who's the person that they're looking up on?
Make a public records request. Go on the website and find out. Sometimes it's appropriate, depending on what's going on. Sometimes it's appropriate. I don't like to get involved in people's custody matters. Did that answer your questions?
You had mentioned that the district does not charge for digital copies, but there is a cost involved in collecting the information. What does the state allow for charges of, or providing public records? Because I know that there's a certain
We could
dollar amount.
charge. We can't charge for doing the search or for reading your request. But the law does allow to charge for staff time in processing, collecting, redacting, and things like that. Currently, we do not do that. I will tell you what we do charge for, though, is sometimes people will request video, security video, or bus video, or something like that. And a parent, by the way, is allowed to view that unredacted. If your kid's in a fight and you want to see what happened, you can ask the principal to please go in. May I see this video? You may watch it so that you can discuss it with your child later or whatever. But if you want a copy, I have to redact all the other little faces in there that is not your child. And it's not because just the fact that that child's in school is a FERPA violation. The problem is these have a way of ending up on social media. And I am not going to be a party to someone else's child ending up on social media. So I got to redact all those other little faces. That's expensive. And we can't do it in-house depending on the format of the video and how many others are in there. And we do charge for that, and I can tell you, I had an attorney make the request. We don't redact them, by the way, for court, because then the judge can protect it and make sure it's not reused. But it is thousands of dollars to do something like that, and we would charge if that was the case.
So did I hear correctly that parents are allowed to have access to at least viewing footage from a campus?
Correct.
Okay, and they would go through their principal for that, not a records request for that?
Correct.
Okay.
And there are different, parents or principals want to protect their students, all students. And so if they're reluctant, or if it's in anticipation of litigation, they may direct you to me, but you don't have to make a public records request if you have a reason. Now, if you just want to go around and say, I want to view all bus footage, kind of like the fishing expedition, that's another waste of time. The principal's not going to set you down and say, sure, you can look at 8 hours of video and everything that happened on our campus in the last 8 hours.
And as far as giving a reason for public records request, do you have to give a reason online?
You do not have to give a reason, but what I do need to know is whether it's a commercial, meaning we get requests from data people who want lists, who want different data. If you're going to use it for a commercial purpose, I do charge. But if it's just a parent or a community member, you don't even have to be a parent, you can be a community member, we don't ask for the reason.
Thank you.
Beyond, are you a commercial entity?
Any other questions on that one? Okay, next topic. Thank you.
All right, let's talk a little discipline, because we got a new law in Arizona, and we've taken that law, and somebody asked about this, so that's why. We've taken that law and we've put it into our policies. The best place to find an overview of that law is policy JK. If you do not know how to find district policies, and can I assume everyone knows how to find a district policy without asking me in a public records request? Go on to the ASBA website. It's the public site. It's the Arizona School Boards Association. Look under Policy Bridge. If you click on Policy Bridge, you can scroll through all of the policies of the different districts. Go down to Scottsdale, and you'll see all the different policies. You can't change them. You can't get copies. It's limited access unless you pay them to be a member. But in Scottsdale and everywhere else, actually, because policies are consistent, it is policy JK. So I'm going to give you the highlights. It's also in the expulsion policy and long-term suspension policy as well. But JK gives you a nice overview. It's just the discipline policy. I'm not going to read it to you verbatim. That would be super boring. So here's the bottom line. If a child is under 7 years old, we cannot, unless they have a firearm or are selling drugs, it's 7 or under, expel or long-term suspend them. Under 7 is kind of like, those kids are little. We're not going to kick them out of school before they even start, essentially. And believe it or not, there have been preschoolers expelled from school. I'm not saying it ever happened in Scottsdale, but there have been preschoolers and kindergartners who have been expelled. Charter schools are famous for it as a way to handpick their student population or those students that perhaps they find they don't want to serve within their community. So we get a law. Under 7, it's pretty much no. That doesn't mean, however, that your school site administrator's hands are tied. There are many, 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 many things they could do for kids who are struggling behaviorally on campus or in the classroom. In fact, it's only limited by your creativity pretty much. And that's up to and including evaluating that child for perhaps some special education services if we have reason to believe that the child's behavior is a result of a disability. So hopefully we don't have very many kids under 7 that we would want to long-term suspend or expel. So then we move to the kids between what they say is kinder and 4th grade, over 7. Those students can be long-term suspended or expelled, but there's criteria that we have to meet. One is that the behavior has to be severe and pervasive. The other is that we've had to try a whole bunch of things, interventions, behavioral interventions, before we just go straight to discipline. The idea of the law is that you're going to intervene in a way that's helpful to the student before you go right to just simply excluding them from campus is a disciplinary action. That, again, does not mean that behavior plans can't be put in place, safety plans can't be put in place, that the student can't be removed from the classroom for a period of time. Not in-school suspension, that's still a suspension. So you still have a lot of tools at your disposal, and there are exceptions. If the student brings a gun, again, we're talking like 4th grade and below, but it's not out of the realm of possibility. Drugs, selling drugs, having drugs on campus, those kind of things, we can still exercise our powers to discipline. We're probably still going to have to then come back with some kind of interventions before we go to the formal expulsion, but we can certainly suspend that student from school. We can get, our special education evaluation teams involved. The frustrating thing for parents, and I suspect this is what prompted the question, is while we're helping this kid who's having behavioral challenges, it can be impacting the rest of the classmates. And I understand the frustration. It's a balancing act. And you asked one of my roles. I do actually, because I have a little background in behavior. I actually worked at a psych hospital once too. A lot of times with principals saying, what can we do to balance the rights of all the students? We have a responsibility to all students. We have a responsibility to this student who's struggling, but we also have a responsibility to the teacher and the classmates. And so it may look like the administration is doing nothing and letting that child run amok and be a menace. Please know that in every instance that I'm aware of, and it's possible I'm not aware of every incident, that the administration is working really, really hard to help that student and keep other students safe. It can be a continual conversation, but we are limited by the law because we have to do some things before we just go to a disciplinary consequence. And there are exceptions. If the child is in imminent and immediate danger, and danger has to be real danger, like someone's going to get seriously hurt, clearly we can give that child a few days at home. But we still have to come back and address that behavior. So the new law put in place really some parameters for our youngest students when we can go right to disciplinary consequences and kind of a checklist or a list of things that we have to do first. Essentially exhaust all options. Suspension or expulsion should be the very last thing on the table, particularly for our youngest students. Remember, we're talking kids 4th grade and under. So that's kind of the discipline in a nutshell. Once we accept a student under open enrollment and we're getting paid by the state of Arizona for that student, they are ours. We would not transfer a student. The expectation, I know that there are schools of choice within SUSD where the parents sign a contract, for example, and that they agree to adhere to certain attendance rules and certain homework expectations and things like that. But when you're really talking about a student with challenging behavior, I worry about, A, you're just transferring the problem to another place, probably. B, that it looks retaliatory and discriminatory, particularly if we're undergoing some kind of special education evaluation. So when you ask a lawyer the question, never or would you ever, I'm not going to say absolutely never, but it would be really, really rare that we would simply transfer the problem from one place to another.
I can speak for Cheyenne, which is a school of choice, and I've been there for 8 years, but we have never, every child that's in our school is treated the same as any child who would be in their home school. So we don't say, you know, hey, you're not working out here, you need to go back to your home school. If it's a matter of discipline, we go through the process of discipline on what's required, but we've never expelled a student from our school to go back to their home school, whether it's one of our own schools or another school at another district. We treat every student, like Lori said, as if, I mean, they are our students. Does that make sense?
Yes, ma'am.
I was just curious, if they're expelled from one SUSD school, can they attend another SUSD school?
If they're expelled under the actual legal definition of expulsion, then they are not really going to attend school anywhere because most other schools will not accept them. Here's the caveat. If a student has a disability, we can expel them and say they can't attend a campus school, but the district is still responsible for providing a free and appropriate public education. If it's simply a discipline issue and that student is expelled, they would be expelled from the district, although we have an alternative to suspension or expulsion, and maybe that student goes to Seoul, or there's some other arrangement so that the education continues, but they're not in contact with other students. And usually, that's why if you notice on our open enrollment form, it'll say, has your student been a part of the expulsion process? And if that's the one place where if they lie and say no, and we found out later when we get the records, we can revoke open enrollment for that. It's kind of a little detour there.
Just, I guess, an A and a B. So when do restorative justice practices start? At what grade? And then how does that impact the, level 1, level 2, level 3 incidences? And, okay, we've given you enough chances. Unfortunately, this is not going to work out. Like, how does that process work?
So the law actually accounts for that and talks about interventions. It doesn't use our language, which is multi-tiered systems of support. But I don't tend to get involved at that point. It can start in kindergarten. Restorative justice, depending, talk with Shannon Cron. Restorative justice type practices where you have, kids learning social skills, learning appropriate behaviors, realizing the impact that their behaviors had, kids talking with each other, things like that. We also have Title IX if you think that the behavior was based on sex, gender, that kind of thing. And we follow Title IX, and we've had kids as young as third grade have to, I've done a Title IX investigation. Well, I don't do the investigation. For kids as young as third grade. So all of those things, that's what I mean by, well, you can't, long-term suspend or expel them, but you can use every other tool at your disposal to kind of help continue to keep that kid in the educational environment.
I had a question about the expulsion process. So you said that if a child is expelled, then they are unable to attend another SUSD school. But if they are going through that process and then the parent withdraws the child before they're officially expelled, are they then able to attend any SUSD school?
No.
Okay.
Because they are going through. The expulsion process is our most formal legal process. We essentially create an the site administrators do in conjunction with Shannon Cron, creates an expulsion packet. We have to hire a hearing officer who then hears the case, makes recommendations to the board. The board then actually determines whether or not that student is expelled. And expulsion does confer due process rights on the student who's being expelled. They can hire an attorney. They get to, question our witnesses if we bring any. They get to do, a variety of things that protect their rights as well. We do enter into stipulated agreements sometimes if that seems to be what's in the best interest of everybody, where the attorney, usually it's when there's two attorneys or the parents, say, we're going to do X, Y, Z, we're going to withdraw from your district. Maybe that's really, we just needed that, and then they can go enroll in another school. But if that other school asks, have you ever been involved in an expulsion process? And it's in the records. So the expulsion, you can't get out of it. You used to be able to, about 10 years ago or so, but you can't anymore. So you can't withdraw just to avoid expulsion. That's still considered like you were expelled.
Right. And
outside of a settlement maybe that the attorneys made.
And the other question I had is when you said that K through 4th, it's very rare that a child gets expelled, but are there any offenses where they are expelled on the spot for that?
Weapons, firearms.
Okay.
Drugs. We could talk about really serious bodily injury, maybe falling under one of those exceptions as being imminent. But even then, remember, you also got that severe and pervasive component, not for firearms, not for drugs, but read policy JK, and it actually really clearly sets out kind of each thing that has to happen and what the exceptions are, and there are a few.
Okay, last question on this topic.
Thank you. With regard to the creative interventions, if there's different schools with different resources, so if there's 29 schools in the district and there's tax credits available, more tax credits available to some more than others, some schools have more. Is there a more ability to be creative?
No. Tax credit money can only be used for extracurricular activities.
Okay. But what about
That's the short answer.
the PTO donations and
PTO would
paras?
not be able to pay the salary of a para. They would not be able to donate any. They're not supposed to be. They're not really, it's my understanding, PTOs are not supposed to be supplementing what salaries of employees.
Okay, so I think there might be
We'll
some
look into that.
violations everywhere.
No, that doesn't happen anywhere, and it shouldn't be happening. I will look into that. There may be a way that they structured it, but PTOs, as a general rule, should not be paying the salary of a staff person.
That will have to be a follow-up topic, because that's a good topic.
I did not know about that.
Okay, next topic.
That's interesting. Well, tax credit money can't still be used for that. Tax credit money, PTO money, I will look into that and see how it's structured, but it's my understanding that PTOs can't pay salaries. I would not be okay with that if that's what they proposed. And I could give you 100 lawyer reasons why that gives me heart palpitations, as well as the PTO paying any staff member that's in the classroom. But we'll look into that because I was not aware that that was happening. And I'm not gonna come down on the PTOs. I'm not gonna undo any good work that you've done. Well, there's tiered systems of support, and that's what was referred to over here. We have level 1, 2, 3 systems of support that's available to all schools. It should not be a resource issue. And if anyone thinks it's a resource issue, I would like to know, because it probably isn't, and there's probably a way that we can work through that. Because that would be inequitable, and that would not be legal if we're expelling at a disproportionate level one group of students and not another. That's why it gives me heart palpitations. All right. Policy JK. That's where you're going to look for that. All right. I'm tempted to stand all the way back here when I start discussing this stuff. Parents' rights. I'm not even going to make you go to the law. I'm just going to make you go to another policy in Scottsdale and in any other district, because ASBA codes all their policies the same. It is policy KB. This is parent involvement in schools, also known as the Parent Right Bill. Again, I am going to summarize this because it's pretty darn long. You have the right to information, and you should ask for that information. You have a right to ask questions about curriculum. You should have access to what clubs are available and what those clubs do. There's a segue here somewhere. You have a right to know whether or not the teachers are highly qualified. There's many, many things that you as a parent have the right to. And it's information, because you need that information to determine how to direct the education of your child. In Arizona, right now, today, ask me again at the end of this legislative session, the answer might change. In Arizona, right now, your right to direct the education of your child is to choose a public school, a charter school, a private religious school, or to homeschool. The state nor the district will interfere in any way. We are a very strong choice state, and you have many choices. I would like you to choose us. That's my little infomercial there. You have a right as a parent to opt out of assignments that are harmful to your child. And harmful is defined by statute. Harmful is not, gee, I don't like it. Wait, I'm going to go back here. Harmful is not, I think they might maybe be teaching CRT. Harmful is not, I don't like this book because I heard my neighbor's friend's kid read it and they were upset by it. Harmful is really defined as something that is against the parent's religious, is derogatory towards the parent's religious or moral beliefs, or is lewd or sexual, explicit. It's not anything you just say, you know what, I really just don't want my child exposed to that, therefore I'd like them to sit in the library while this particular thing is going on. You can make that request, and you have to say what you find objectionable And if it is indeed objectionable, according to the statute, your child will get an alternative assignment. And you can structure that with the teacher. I would encourage you to involve the principal in that. What you can't do is opt out of an entire class that's required, or it's part of the program. I only want my child to take these 4 classes, but you know what? I don't think they need these. That's not what the Parent Bill of Rights says, because unless you can say there's something harmful, per Arizona law, you've chosen public school. You don't get to direct what the school does then. And if you think that's just me, it's not. It's our Attorney General and the Ninth Circuit, which is the circuit that Arizona falls under. So that's just not me. That's language from the law. And I know that's a struggle. And I don't want to say, you have so many choices. If you don't like what we do, leave, because I think Scottsdale's a really great place to be for kids. I wouldn't be here if I didn't think that. I wouldn't work for people if I didn't think that. This leads into what we're talking about when we're talking about clubs. You have the right to say what clubs are on my campus. Or I want to send my kid, my kid's going to middle school maybe. What clubs are on their campus? What clubs are on the high school campus? We really don't have clubs. We have after-school activities on the elementary campus, but we don't have clubs in the same way that we do at middle school and high school. You can get information about those clubs. If I was a parent today, and my kids are all grown, my youngest is 21, and someone said, my kid came to me and said, Mom, I want to join the manga club. I learned this from a student the other day. It's, Mom, I want to join the manga club. I would go, really? What is the manga club? And I might reach out to the school and say, what's the manga club? It's a form of anime, by the way, for all of you who don't know. Like I did not know. You have a right to know that. And then decide, as is your right as a parent, is this right for my child and my family? And if the answer is no, then you say, you may not join that club. What you don't get to do is say no child can join that club, because I don't like that club, and it's the wrong decision. And I respect everybody's decision to do what's right for their child and their family, and I will defend that right if a principal asks me. But you don't get to decide for everybody else. That's not what the Parent Bill of Rights says. So let's talk a little bit more, and I know I talk fast. I'll pause right there to see if we have any questions. And then I'm going to move into clubs.
What if that club causes harm to other clubs or individual students? So, for example, you talked about, the harm part before. What if it, has a sign that says, we hate so-and-so, or we just, that type of
Good
thing?
question. That's an excellent question. So again, we have a policy for that. And I can even tell you what policy it is, maybe. Let's see. We have a policy, while I'm looking for that, by the way, we have a policy already about teaching controversial subjects. Scottsdale's had this policy, by the way, since 2009. So if you're worried about teaching controversial subjects and what Scottsdale's position is on teaching controversial subjects in class, look at policy IMB. And the title of that is Teaching About Controversial or Sensitive Issues. There is a policy that says that a club may not engage in activities that are discriminatory, dangerous, or disruptive to the campus. And please remember that, and I'll go right into clubs, and I will get you that policy, by the way. Clubs must have an adult supervisor. However, clubs in SUSD are formed by student interest. They are student-led. They are student-directed. The role of the advisor is, one, to supervise the kids if they're of age that they need supervision, but it's also to maybe assist them because, you know, they might not know how to write an email contacting someone if they want to do a fundraiser or something like that. What the advisor doesn't do, or they're not supposed to be doing, as far as I know, it's not happening, but as we have seen, there are things happening, not surprisingly, that I don't know about. They can't stand up and give a lesson. They can't stand up and say, this is what this club stands for. Clubs are protected under the Equal Access Act and under Arizona statute in middle school that applied the Equal Access Act to middle school students. So the argument that I keep getting is, yeah, but it doesn't apply to middle schools. By Arizona statute, it does. That there's some kind of curriculum going on. There's some kind of subversive something going on in the club. There shouldn't be. The advisor of the club should not be standing up there and telling the students what to think, what their discussions need to look like. Most of our clubs, I mean, we've had everything from a Taco Tuesday club to manga clubs. We've had, there's a wide variety of clubs. The reason we have clubs is because it gives kids a place to belong. And for some kids, that's the only place they feel like they belong and that that's their peer group. We would not allow students to engage in self-harm in a club. We would not allow students to do something illegal. We can set parameters. What we can't do is tell one club, we don't like your viewpoint, so you can't be a club. We don't like what you're talking about as students in that club, so you can't be a club. We're not allowed to say that by federal law and by Arizona law and by all the anti-discrimination statutes. And so that's where people get concerned about clubs. So why don't we ask for parents' permission? Well, if your child joins a club, it's voluntary. It cannot be during instructional hours. It can be at lunch. We're not providing instruction at lunch. And it's after school. Again, as a parent, you can tell your child no. And if you've told your child no and you think they're sneaking off to join a club that you don't think they should, please contact your administrator and they can tell that student, you're not allowed to be here. Gets more problematic when the student is 18. Then you don't get to say that anymore because in Scottsdale, when a student turns 18, they hold all their educational rights. And I know that's not how it plays out in practice. That's what it says in policy, though. So you cannot have a club, nor would anyone want to author or be the advisor of a club. At the high schools, the clubs are approved by the student government. And so they look, and the clubs all have to have charters and what's their purpose, and student government looks at that, and then the principal also approves the clubs. So if there was any true discrimination going on under any of our statutes, or they said the purpose of their club was to do TikTok challenges and destroy bathrooms or whatever, no, that would not be allowed to be a club. But we can't just pull clubs because of their viewpoint. We have a Young Republicans Club. We have a Young Democrats Club. We have a Turning Point USA Club. We have Fellowship of Christian Athletes. I mean, I think one of the high schools, I'm not sure, has a black student union. They don't call them black student unions, but I mean, we have, what we couldn't have, though, is the white supremacist club. Number one, we would never find anybody to do it. Number two, that would be disruptive and discriminatory against another body of students on the campus if they engaged in activities. We could have a critical race theory club, though, where the students wanted to talk about it. That's simply a viewpoint. And I know that concerns people. And I respect everyone's viewpoint, but again, you get to make the decisions for your kid, but not for everybody else's kid. So go ahead, hit me with all the club questions.
So at the site level, who has the authority to say yay or nay for a club? Is it just based on student interest and a teacher that will sponsor it, or no?
No. Student interest, a teacher who will sponsor, student government, vets, and make sure they meet, like they've had their charter and they meet the requirements that they've set out, and then the principal.
The principal, okay.
So it's a multiple, but level process. But again, the principal's discretion is only as to, is this going to be harmful on the campus? Is it, going to cause disruption? Have they followed the process? Those kinds of things.
Thank you.
All right, I'm trying to think what I forgot. And I need to see, you asked me about clubs, you asked me about me, you asked... I don't know. What other questions you got?
Sorry, it's loading.
That's okay.
Just wanna-
You want me to pull it up?
What is the status of HB 2112, the quote, teacher gag bill?
Oh, I
and there
didn't
was
see that
another
one.
one,
I didn't
too.
get an updated question. The status is it's working its way through the legislature. I will tell you that, again, look at the controversial subjects and how teachers are supposed to answer or teach. I would hope that even if a bill were to pass, that we're already in compliance with that bill. But I will tell you the teacher gag bill is working its way through the legislature. It was pulled last time because it didn't comply with the single subject rule. The Arizona Supreme Court pulled it, as well as that schools can't require masks. So it has to work its way back through the legislature. And if it gets the votes, it's got to get the votes in both the Senate and the House, and then go to Governor Ducey. I don't know what's going to happen with it. It is back. It says, essentially, without reading, and I actually haven't read the most recent version of the bill, essentially that teachers cannot teach anything that makes one student feel less than another by virtue of race, gender. I think that's in this new bill. I don't think gender was in the last one. And that anything that makes a student feel uncomfortable, maybe, maybe not. Maybe not. In the last bill, there was a fine. I don't know whether there's going to be a fine. There's also talk about a bill working its way through. The Parent Bill of Rights right now really has no definite enforcement mechanism. There's some talk about putting some kind of penalty in that, and I really don't know. I mean, they've come out of committee. Some of them have had votes in the full House or Senate, but I am hesitant to opine. I know what they won't do is stick it in the budget reconciliation bill this time, we would hope. But we'll just have to keep watching it. There is a Council of Exceptional Children, I think, has a bill tracker, as well as ADE has a bill tracker. And you can find the status of all the bills. You can also call your senator or your congressperson at any time to express your opinion one way or another as to how you would like to see legislation shaped. Because if they're going to enact legislation, I think they should hear from everybody. What they'll do, I wish I knew.
We have a handout of how to find your legislator and their contact information, so that's at the door. Okay, there was one more in the forum that I'll say, and then we'll have a couple minutes for any other questions people have. There has been much discussion of the Afghan refugee children enrolling in SUSD. Some parents have expressed concern about not being, quote, informed by school admin about their enrollment. Is the district legally obligated to inform parents of their enrollment? Presumably, it would be illegal for the district to disclose such information to parents, correct?
So here's the deal. I hate when people throw around words like illegal, because I don't know what they mean when they say, is it illegal? We have protections under our laws, and they're here under our laws at the invitation of our governor and at the invitation of our country. They are subject to FERPA laws. They are subject to non-discrimination laws on the basis of nationality. We are not going to call out those individuals. We treat them like any other family moving into our district because that is what they are. They may have come in a larger group, but they are families that are moving into our district. We treat those students, we do not notify the community when any other student moves into the district, and we are not going to notify the community when another group of students moves in simply because they are refugees. That would be discriminatory. So if that's what they mean by illegal, yes. We will also not tell you how many kids went to what school and how many are English language learners. That would be a FERPA violation, Family Educational Rights Privacy Act. We're not going to do that. These are students that we have the privilege to serve, and we are going to welcome them into our community. And no, there was no right of the community. There's nothing the community could have done other than what was really great, which is what can we do to help? How can we support these students? There was, and no, there was no reason. We have a great team in place, just so you know, at the district level, to provide all the supports to staff as best we can, and to support these students because they are going to have some unique challenges, clearly, moving into the district. And we have marshaled a lot of resources. They are sponsored by an agency. They are here legally. They are not here illegally. They are here legally. And we are doing everything we can to actually help them want to make Scottsdale their permanent school home. So, no, we had no, but we did tell the community what we could tell the community. And they responded in an overwhelmingly positive way for the most part.
Okay, any other questions from anyone?
Just on the question you said about withdrawing children from assignments that could cause harm. In terms of state testing, particularly as regards special ed children, what are the rights of special ed parents, particularly in withdrawing from?
No child gets withdrawn from state testing. All students, we have, this is going to be a complicated, this is like an in-the-weeds discussion. So students with special education are largely protected under the IDEA as well as anti-discrimination laws, 504s, things like that. In Arizona, all children get tested. An IEP team can determine that the child take the alternative assessment, which is, again, a state test designed and well, it may not be designed, but it's vetted by the state. And we're only allowed to have 1%, I believe, of those students not take the test. Now, parents don't show up. Look, let's not be, all parents opt their kids out. They just don't have them show up, and it depends on the district how long they keep the window open to make those kids sit there and take the test. There is no opt-out provision for testing or assessment in Arizona for any student, no matter how disabled they are, because we do have a testing instrument should the IEP team, and again, I could go through all the criteria for that, but I won't, determine that the student needs what's called an alternative assessment. So there is no opt-out provision, nor should we be opting out our students with special needs. We can agree to disagree on that. It's a civil rights issue, so, I mean, we'll follow the law until the law changes. If there is an opt-out provision for all parents, then certainly that same opt-out provision would be available to our students with disabilities.
Any other questions? No? Okay, well, Lori, thank you so much. That was very, very informative.
I said anything I wasn't supposed to, Christine can yell at me later.
Okay. We have a few executive board updates. First, Jane, did you want to do this for us? Our budget report with our treasurer, Jane Trapp.
So our financials, we're spending and getting revenue all on target. We would like more individual contributions, so if you guys would like to contribute, feel free to go to our website. And that's pretty much it, unless you have any questions.
Okay, thank you, Jane. Okay, so as Dr. Menzel mentioned, the aggregate expenditure limit. This is the wonderful graphic that the Chaparral PTO put together and has shared with other PTOs, and thank you, I've seen that in a bunch of newsletters. And that QR code links to all of the information they also provided with sample letters to legislators. So as he mentioned, the status is that yesterday was a vote in the House, that passed the House, and then they had expected today to vote in the Senate on it. They have to vote for a similar bill, and then it goes to the governor. But they did not take it up in the Senate today, presumably because they didn't think they had the votes to get it passed. So there's still an opportunity to provide input on that to your state senator. They're listed there, but as I mentioned, there's also a handout on the door on the way out there that you can grab. And again, if you're not familiar with it, there's lots of information that the district has put out and that a lot of the PTOs have put out as well. And feel free to ask any questions of any of us board members after the meeting. In terms of upcoming events, so we have a special event on March 2nd from 5 to 7 on Zoom, and it's on news literacy. So we have a special organization coming to present. It's Rose America, and they're in partnership with the News Literacy Project. So it's going to address things like what is misinformation, why it spreads, fact-checking and verifying information, what are the skills you need, and how to have a conversation with someone whose beliefs are based on misinformation. So I think it'll be a webinar version, but like I said, it's on Zoom, but there'll be some activities. It's for parents, and I think it's appropriate for older kids as well. And then our Gifted Education Committee. So they have their, do you want to talk about it? Oh, she said no. Okay, so their next meeting is February 22nd here at 6 o'clock, and it's the parenting playbook, raising gifted and twice exceptional kids. With Emily Kirchner Morris is coming as a special speaker for that. So everyone is welcome to attend those meetings, and then they record them as well and make those available after the fact. And I forgot to mention our next SPC meeting, the March meeting it's on school safety. So we have James Dorr, the head of safety and security for SUSD, coming to talk about some of the policies and procedures. And we have Shannon Kront coming to talk about how the district handles threat assessment. And then I believe Melissa Sakos will be joining as well. She gave a presentation recently at a board meeting about that parent survey on the officers on campus and some other topics. So I think she's going to be joining us as well to talk about that. And then in terms of our committees, so the Equity, Diversity, and Inclusion Committee wanted to share that they have a new Instagram and Twitter account. It's SPCXEDI, and they've been posting a whole bunch of fun content on there. And then on our Facebook page, there's been a lot of Black History content. Thank you, Stuart, who has been posting that on a daily basis. And then they are working as a committee to research the Native American histories of several of the SUSD schools that are named after tribes, as well as the land that they are located on. That is the only announcements. Do any SBC representatives have any announcements? Okay, and then with that, that is the end. So feel free, come and ask me any questions if you have any questions about the aggregate spending limit or anything along those lines. So thank you very much for coming.